Hello and welcome to this month's 3PB Employment Case Law Update, which is being recorded at just after 8 AM on Monday, the 19th of October 2020. My name is Craig Ludlow and I am the head of 3PB's Employment and Discrimination Law team. I'm joined today by my brilliant colleague in Chambers, Sarah Clarke, who in the recently published Legal 500 rankings is described as fearless, great at cutting through the irrelevant and focusing her cross-examination on the core issues. Good morning to you, Sarah.
Good morning, Craig.
So over the next 40 minutes or so, we're going to be discussing the facts and details of three recent Employment Appeal Tribunal cases and one very interesting first instance decision. And they are, in order, just in case you want to fast forward this recording, to get to the case you're interested in, and case references will be, you'll see, I hope, in the bottom left-hand corner of your screens as I say the cases. So firstly, K and L, which deals with whether or not there is a different burden of proof in relation to misconduct cases, where there is a possibility that an employee who works with children may pose a danger to them. Sullivan and Berry Street Capital Limited, which deals with the rejection of medical evidence in disability discrimination cases and the application by tribunals of the constituent parts of the term disability under the Equality Act 2010. Jackson and Liddell Great Britain Limited, which deals with the issue as to whether or not Stoicism is a philosophical belief under Section 10 of the Equality Act. And fourthly and finally, a case called Aramark UK Limited and Fernandez, which deals with whether the failure to place a redundant employee on an existing bank or pool of workers list makes a dismissal unfair. So Sarah, I'm going to hand over to you to deal with the first case, K&L, please.
Hello everyone. Yes, so the first case is a recent EAT decision. In that case, the claimant had been employed by the respondent school for 20 years as a teacher. In December 2016, the police entered his property, having been granted a warrant to search for and seize computers in possession of the claimant. The warrant was based on intelligence that indecent images of a child or children had been downloaded to an IP address associated with the claimant. The claimant lived at that address with his son. One of the computers was found to have data that was of interest to the police. The claimant advised the head teacher that he was involved in a police inquiry into potential indecent pseudo-images of children, and he denied that he had anything to do with it. He was suspended whilst the matters were investigated. The claimant was charged with possession of indecent photographs of children. However, the Crown decided not to prosecute. The letter advising the claimant of this stated that, "I have now reviewed the case and have decided on the basis of current information available to me to take no further action against you at this time." The claimant had been expecting the letter to state that there was no case to answer. He therefore made inquiries with the Crown, explaining that as he was a teacher, in order for the school to make an informed decision about his continued employment, they wished to establish what evidence they had against him. The respondent also requested such information from the Crown. The Crown responded, stating that they had enclosed a copy of the summary evidence, which was provided only for the purpose of their investigation and was not to be disclosed to anyone else. This letter was produced in evidence to the tribunal. However, the whole paragraph containing the summary of the evidence was redacted. The respondent's HR advisor did not share the summary of the evidence with the head teacher, who was the other investigating officer. The head of service, who conducted the disciplinary hearing, had no knowledge of this letter. An investigation report was prepared which stated that the charges by Police Scotland of being in possession of a computer with indecent images are of a serious nature, and if it became publicly known, this may have brought the respondents into disrepute. The claimant was invited to a disciplinary hearing. The allegation against him was that he was involved in a police investigation into illegal material of indecent child images on a computer found within his home. No reference was made to the possibility that if the allegations became known, this might cause reputational damage to the respondent. At the disciplinary hearing, the claimant accepted that the police had found indecent images on the computer. The claimant stated he did not know how they got there. He pointed out that he was not the only person with access to that computer. He shared the house with his son, and both his son and his son's friends had access to the computer. The tribunal found that although the subject of reputational loss was referred to by the senior HR advisor during the hearing, there was a limited amount of discussion about it. The head of service concluded that there was insufficient material upon which to conclude that the claimant was responsible for downloading the images. However, she decided that the claimant should be dismissed for the following reasons. As a consequence of the set of circumstances which have arisen, risk assessments have concluded that it would present an unacceptable risk to children for you to return to your current teaching post or any current vacancy within the council. If in the future, either by criminal prosecution or otherwise, it was shown that you had committed an offence involving indecent images of children, it would cause the council serious reputational damage if we continued to employ you in any post in circumstances whereby it became public knowledge that we were aware of the allegations against you, and yet we continued to employ you. The claimant brought a claim for unfair dismissal. The claimant was dismissed and he appealed on various grounds, including that, firstly, the invite letter to the disciplinary hearing did not give him notice that he was at risk of being dismissed on the ground of a risk of reputational damage, and also that the tribunal had erred in finding that the conduct dismissal was fair, given that the school concluded that there was insufficient evidence to conclude that he had downloaded the photographs. The matter went to the EAT and was heard by Lord Summer. In relation to the first issue, the notice of grounds given for the invite to the meeting, the tribunal did accept that whilst the reason for dismissal was different in nature to the allegations which the claimant faced, it concluded that the invite letter did reflect the matters for which he was dismissed. However, Lord Somers concluded that this was an error of law. Case law has made it clear that an employer must give notice to an employee of the ground on which dismissal was sought. This was set out in the case of Strouthis and London Underground Limited, 2005. This requirement is consistent with the basic requirements of natural justice that an employee should know the ground of complaint he or she faces. It is also consistent with the idea that the complaint should enable the employee to show what issues he or she should be ready to address by way of suitable evidence and supporting submissions. It is insufficient for the matter simply to be referred to in the investigation report. As the case of Leach v. the Office of Communication shows, reputational damage secondary to misconduct is regarded as a separate ground of dismissal and raises a set of considerations that are connected to but distinct from dismissal based on misconduct. The matter of reputational damage was not addressed by the claimant, and this is a matter on which detailed submissions and suitable evidence would have been of benefit. Therefore, this ground of appeal was upheld. In relation to the standard of proof required, it is noted that the decision to dismiss here was made on the basis not that the claimant had, on balance, downloaded the images, but rather that there was no absolute guarantee that he had not. This approach was endorsed by the tribunal. The claimant argued that the incorrect burden of proof had been applied and relied on the case of Reeby Children 2008, in which it was held that if a legal rule requires a fact to be proved, a judge or jury must decide whether or not it happened. There is no room for a finding that it might have happened. The law operates a binary system in which the only values are 0 and 1. The fact either happened or it did not. The employment judge did not consider that these observations were relevant to decisions made by employers in an employment context. However, Lord Somers disagreed. He was of the opinion that the head of service was fulfilling a quasi-judicial role and concluded that the obligation on an employer to act reasonably and in accordance with equity required the respondent to apply the balance of probability test. Plainly, she was not permitted to guess. Some objective standard had to be applied. It was unreasonable to apply a test that in effect entitled the employer to dismiss unless all doubt as to the claimant's guilt had been excluded. The Birchall guidelines indicate that the employer must have reasonable suspicion amounting to a belief that the employee is guilty of the conduct in question. Given that it was concluded that there was insufficient evidence to show that the claimant was guilty of misconduct, the head of service could not have had the requisite belief. The proper question to have been asked was whether it was likely that the claimant had downloaded the images. This ground of appeal was therefore upheld. The EAT also went on to comment upon the issue of reputational damage. The Court of Appeal case of Leach v. Office of Communications 2012 was relied upon by the respondent in support of the argument that the finding that the dismissal was fair on the basis of reputational damage should be upheld. In the case of Leach, the employee was in a senior position. During his recruitment process, he was arrested in Cambodia on charges that he had sexually abused children. That case generated great press interest. He had given false information to the press about his employer's identity. However, the case against him was later dismissed. He did not advise his employer about these matters. When his employers later found out, they investigated the allegations and were satisfied of his innocence. Thereafter, a body called the Metropolitan Police Child Abuse Investigation Command, or CAIC, got in touch with the employer and warned that they had intelligence that indicated that he had engaged in paedophile activity in Cambodia. They disclosed to the employer that the employee had pretended to be a doctor in order to gain access to children in Cambodia, and that he had frequented brothels in Cambodia known to supply children. This led to a disciplinary hearing where these disclosures were discussed. The employer expressed a concern that if these allegations turned out to be true and became public knowledge, they would suffer reputational loss if they continued to employ him. Mr. Leach was dismissed, and his claim for unfair dismissal failed. Lord Somers distinguished this case, finding that the facts were very different to the present situation. For example, the employer had been provided with detailed information in Leach, which tended to support the allegation of misconduct. The employer there had critically analysed the information they had with the employee and had sought to establish the reliability of the police evidence so far as was possible. There was press coverage of this matter, and the press advisor had evaluated the risk of adverse coverage and considered it to be a real one. Now, the case of Leach demonstrates that dismissals based on reputational damages may be fair, even though the conduct giving rise to the reputational damage is disputed by the parties. In these cases, given the nature of the allegations, there is an understandable reluctance to require the employer to make a finding as to the truth or falsity of the allegations. The Court of Appeal in Leach observed that the employer did not decide that the employee was in fact guilty of the matter disclosed, but nevertheless was entitled to treat the information received from CAIC under an official disclosure regime as reliable. It was entitled to conclude that the responses of the employee were not wholly convincing, and not as convincing as they had been in the past. Lord Somers distinguished the case also on the basis that, as the head of service had not seen a summary of the evidence, the claimant had been dismissed in ignorance of what kind of images were downloaded, what level of gravity they were assessed to have, how many images were downloaded, when they were downloaded, and whether or not they may have been accessed remotely. Further, there was no indication that the employment judge had applied the guidance in Leach to the question of dismissal on the ground of reputational damages. So clearly, the EAT here is providing helpful guidance to employers who may be navigating this extremely difficult area. It can be all too easy in a situation in which there is a serious allegation made against an employee who works with children to have a knee-jerk reaction and to dismiss on the basis that any risk is too great a risk. Understandable though this may approach be, the EAT have made it clear that this is not the correct approach to follow. Understandable though this approach may be, the EAT have made it clear that this is not the correct approach to follow. The usual standard of proof applies in conduct dismissals, and the employer must come to an informed decision as to whether, on the balance of probabilities, the employee is guilty of misconduct alleged. They must critically analyse all of the evidence and seek to establish the reliability of such evidence where possible. However, it strikes me that there is something of a tension between the approach of Lord Summer here, i.e. that an employer must make a finding as to the guilt of the employee, and the judgment in Leach. In Leach, the employer had not decided that the employee was guilty of the matters which were brought to their attention, yet it was found that the dismissal was fair. This was on the basis that it was found that they had been entitled to treat the information and viewpoint of the CAIC as reliable. This tension arguably can be resolved by the fact that in Leach, whilst misconduct had not been established, the dismissal was held to be fair on the basis of some other substantial reason, namely reputational damage and loss of trust. Employers may thus wish to consider that, if misconduct is likely to be difficult to prove, other potential grounds for dismissal, such as reputational damage or a loss of trust and confidence, should be relied upon as an alternative to conduct. Indeed, this is likely to be the safest approach to take in such situations, as clearly the employer is not in a position to carry out their own full investigation into the alleged misconduct, and may well struggle to form a reasonable belief in the employee's guilt in relation to events which occurred outside of the workplace and to which they have no witness evidence. If an employer does go down the route of relying upon reputational damage, this must be treated as a separate allegation to misconduct and not simply tagged on to the reason for dismissal at the end of proceedings. An employee must be given sufficient notice of such an allegation.
I'm next going to go on to speak about the case of Sullivan and Berry Street Capital Limited. Now, there's a rather interesting factual background to this case. Mr. Sullivan was employed as a senior sales executive with a small finance company called Berry Street Capital Limited, which I'll refer to as the respondent from now on. That employment ran from 2008 until Mr. Sullivan's dismissal in September 2017. Now, from the outset of his employment, there was a degree of tension between him and the respondent's chief executive, Mr. Drake, due to the relaxed attitude taken by Mr. Sullivan to matters such as observing office hours and documenting his activities. Between March and May 2013, Mr. Sullivan had a short relationship with a Ukrainian woman. Following that relationship, he became convinced that he was being continually monitored and followed by a gang of Russians connected to the Ukrainian woman. He believed that his use of telephones, emails, and the internet were all under surveillance by them, and that he was being watched and followed when out in public. Mr. Drake became aware of Mr. Sullivan's beliefs about being stalked by Russians in about July 2013. He thought Mr. Sullivan was in a bad place psychologically and physically, and that he was shaking and sweating. He thought Mr. Sullivan was exhibiting extreme paranoia, which was a figment of his imagination. Now, figment of his imagination or not, it did affect Mr. Sullivan's timekeeping, attendance, record keeping, and general behaviour at work. In September 2013, Mr. Drake asked Mr. Sullivan to join him on a business trip to New York. During the trip, Mr. Sullivan looked and performed well at meetings, and he informed Mr. Drake that his condition was improving. By February 2014, Mr. Sullivan consulted a doctor about the problem he believed he was having with the Russian gang, but it was noted by the doctor that he was well presented, enjoyed work, and had good client relationships. In May 2014, Mr. Sullivan began to consult a psychologist who noted that his sleep had improved, he was engaging with friends and using the telephone. Although he still believed he was being followed by the Russian gang, he was managing to ignore the issue and was able to concentrate on work. Between July 2014 and September 2017, Mr. Drake conducted regular reviews with Mr. Sullivan. Recurring themes of these reviews were timekeeping and attitude at work, but there was no express reference to the Russian gang problem made in them. In September 2014, a Mr. Isahaho joined the respondent and worked closely with Mr. Sullivan. He knew nothing about Mr. Sullivan suffering from paranoia, and there were no discussions in the office of which he was aware by anyone about that subject. Mr. Isahaho's unchallenged evidence to the tribunal was that he did not notice any significant change in Mr. Sullivan's appearance or behaviour from when he joined the respondent through to Mr. Sullivan's dismissal in September 2017. On the 8th of September 2017, Mr. Drake dismissed Mr. Sullivan with notice, citing the reasons for dismissal as Mr. Sullivan's attitude and the fact that he was not considered to have the skill set to fulfil his role in the business. That included timekeeping, lack of communication, unauthorised absences, and lack of record keeping. Mr. Sullivan lodged claims for unfair dismissal, discrimination arising from disability, indirect disability discrimination, failure to make reasonable adjustments, and unlawful deduction of wages. I think it's worth here just reminding ourselves of the relevant law on disability before we turn to the judgments of the Employment Tribunal and the EAT. And in relation to that, viewers will recall Section 6 of the Equality Act, so far as it's relevant to this case, provides subsection 1, a person P has a disability if A, P has a physical or mental impairment, and B, the impairment has substantial long-term adverse effect on P's ability to carry out normal day-to-day activities. Section 2122 of the Equality Act provides that an effect is substantial if it is more than minor or trivial. Paragraph 2 of Schedule 1 to the Equality Act defines long-term effects as follows. The effect of an impairment is long-term if A, it has lasted for at least 12 months, B, it is likely to last for at least 12 months, C, it is likely to last for the rest of the life of the person affected. And then subparagraph 2 of paragraph 2 of Schedule 1 to the Equality Act says, if an impairment ceases to have a substantial adverse effect on a person's ability to carry out normal day-to-day activities, it is to be treated as continuing to have that effect if that effect is likely to recur. Likely, in this context, means something that could well happen. And that's a reference to SCA Packaging Limited and Boyle, the House of Lords judgment. Now, the likelihood of recurrence within the meaning of paragraph 2.2 of Schedule 1 to the Equality Act is to be assessed at the time of the alleged contravention. And that's a reference to McDougall and Richmond Adult Community College, the Court of Appeals judgment. And finally, on the law, pursuant to paragraph 5 of Schedule 1 to the Equality Act, an impairment is to be treated as having a substantial adverse effect on the ability of an employee to carry out normal day-to-day activities if measures are taken to treat or correct it, and, but for such measures, it would be likely to have the prescribed effect. So, back to the facts of the case and the judgment of the Employment Tribunal. The Employment Tribunal upheld Mr. Sullivan's claim of unfair dismissal on the basis that the respondent had not established the reason for dismissal as being a potentially fair reason, and that the dismissal was procedurally unfair. But the remaining claims were dismissed principally on the basis that Mr. Sullivan did not have a disability within the meaning of the Equality Act, but that even if the tribunal was wrong about that, because the respondent did not have knowledge of the disability. In its detailed reasoning, the tribunal found that, as from around May 2013, there was a substantial adverse effect on Mr. Sullivan's ability to carry out normal day-to-day activities of sleeping and social interaction. By the 27th of July 2013, Mr. Drake had recorded that Mr. Sullivan's belief about the Russian gang was having a significant effect on him. And on the 1st of August 2013, Mr. Drake linked poor attendance and erratic behaviour on Mr. Sullivan's part to this. However, the tribunal concluded that the substantial adverse effect on Mr. Sullivan's ability to carry out normal day-to-day activities did not, at this stage, continue beyond September 2013. It was important in the tribunal's judgment to distinguish between Mr. Sullivan's continuing belief in the Russian gang and the effect that such a belief had on his ability to carry out normal day-to-day activities. The tribunal accepted that Mr. Sullivan's delusional beliefs persisted throughout the material period, but the evidence did not show that a substantial adverse effect on his ability to carry out normal day-to-day activities also persisted. And the tribunal found that there was again a substantial adverse effect on Mr. Sullivan's ability to carry out normal day-to-day activities from at the latest July 2017, or at the earliest around April 2017, as there was a deterioration in his timekeeping and performance. He was, of course, dismissed in 2017 in the month of September. And the tribunal found that during this period, it was not likely that the substantial adverse effect would continue for at least 12 months, as in 2013, the substantial adverse effect lasted only for around 4 to 5 months. And for substantially the same reasons, and having regard to paragraph 2.2 of Schedule 1 to the Equality Act, the tribunal found that the effect was not, either in 2013 or 2017, likely to recur within the meaning of that provision. So in a nutshell, what the tribunal said was that the substantial adverse effect on Mr. Sullivan's ability to carry out normal day-to-day activities continued for about 4 to 5 months in 2013. It did not then apply for over 3.5 years, and then occurred again for something up to 5 months in 2017. In neither case was it likely that the substantial adverse effect would continue for 12 months or more. Mr. Sullivan appealed to the EAT against the decision to dismiss his disability discrimination claims. And the EAT judgment, which is a detailed 24-page judgment by the President of the EAT, Mr. Justice Chowdhury, handed down on the 9th of September 2020. He dismissed Mr. Sullivan's appeal and restated, not that it was in dispute between the parties, that it is not the task of a medical expert to tell an employment tribunal whether any impairment had the prescribed effect. And he referred to President Elias's judgment in the case of Paterson and Commissioner of Police of the Metropolis back in 2007. Now, President Chowdhury did that because part of the evidence adduced in support of Mr. Sullivan's claim to be disabled included evidence from a jointly instructed medical doctor and a chartered psychologist who both concluded that Mr. Sullivan had substantial adverse effects at the relevant times, and one of the grounds of appeal related to the employment tribunal not having given sufficient reasons for essentially rejecting the conclusions of the medical experts. And President Chowdhury said that there was no dispute that the delusional beliefs persisted throughout. However, the tribunal correctly drew the distinction between those beliefs and the effect that such beliefs had on Mr. Sullivan's ability to carry out normal day-to-day activities. The continuation of the former, i.e. the delusional beliefs, is not synonymous with a continuation of the latter, i.e. the substantial adverse effects. An impairment can vary in its effects over time, and it's a matter for the tribunal, having regard to all the evidence, to consider whether it has been established that there was a substantial adverse effect during the relevant period. And that's a reference to paragraph 26 of that judgment. It went on to say that the Employment Tribunal did not err in concluding that the long-term requirement in the definition of disability was not met. The tribunal was entitled to conclude on the evidence that, although there was a substantial adverse effect in 2013 and again in 2017, in neither case was it likely that the adverse effect would last for 12 months or that it would recur. The tribunal had correctly applied likely as if it meant could well happen, and had approached the question of the likelihood of recurrence correctly. And the tribunal also did not err in deciding that the respondent did not know and could not reasonably be expected to know of this disability. Now, in commentary on that case, to my mind, this case is, I think, another salutary reminder of why it's so important for respondents facing disability discrimination claims to really engage with their representatives at an early stage of litigation and apply their minds to the entire factual matrix surrounding any alleged disability. And additionally, it's important for respondents to take the time to carefully go through a claimant's medical records, which are usually ordered to be served after a preliminary hearing, with that factual matrix in mind, rather than just relying on their solicitor's judgment to concede the disability issue where appropriate, sometimes based on incomplete factual detail together with the medical evidence. In my experience, it's often helpful to have the disability issue as a live one at the full merits hearing, as it gives tribunals an extra avenue by which they can give reasons for dismissing disability discrimination claims after having heard all of the evidence, as opposed to hearing just some of it at an open preliminary hearing at an earlier stage. Indeed, in Mr. Sullivan's case, the tribunal essentially rejected his medical evidence or opinion on the substantial adverse effect element of the definition of disability because of factual evidence which contradicted it. Now, just before I hand you back to Sarah to deal with her next case, if you're interested in knowing more about the legal definition of disability and disability discrimination law generally, please do have a look at the news section on our 3PB website and scroll down to the 10th of September, as there you'll find an excellent and comprehensive recorded webinar solely on the topic of disability, which is given by our colleagues Karen Moss and Grace Borer. So Sarah, I'm going to hand back to you, and I think you're going to tell us about Stoicism next, aren't you?
That's right, Craig, yes, thank you. So the next case I'm talking about is Jackson and Lidl, which is an interesting first instance decision of the South London Employment Tribunal on the issue as to whether or not Stoicism is a philosophical belief that qualifies for protection under the Equality Act. Mr. Jackson was a communications worker for Lidl. During the course of his employment, he had made the comment that Asians were greasy. He was asked to apologise for this comment, but refused to do so, or refused to do so sufficiently. Right, he suffered from dyslexia, and he argued that as a dyslexic, he had mixed up his words and that it was not his fault. He was dismissed, and he brought claims of disability discrimination, but also discrimination based on religion or belief, namely that of Stoicism. He was dismissed, and he argued that this constituted disability discrimination and also discrimination based on his religion or belief, namely Stoicism. He argued that his dismissal was an act of both disability and religious or belief discrimination, He also argued that he had been subject to indirect discrimination. He argued that there was a practice of requiring staff to communicate in a way that could not be misinterpreted by colleagues, and that he, as a Stoic, was unable to do so. The matter was listed for a preliminary hearing before Employment Judge Cheetham Kesey, and one of the issues was whether or not Stoicism was a belief qualifying for protection. The claimant's case was that he had a strong interest in philosophy and a thorough knowledge of the principles of Stoicism. He told the tribunal that he believes that there is an objective moral reality to which we are all subject, and that there are several ethical values to which he must adhere to as a consequence of this belief, namely wisdom, courage, moderation, and justice. An important part of his belief is that he is not what he described as a consequentialist. In other words, the consequences of what he says and does not prevent him from doing or saying that thing. His evidence, which the tribunal accepted, was that he was striving towards what Stoics call apatheia, or equanimity. Apatheia is based on the Greek words a, meaning without, and pathos, meaning suffering or passion. Effectively, this refers to a state of mind in which one is not disturbed by the passions. For those of you not in the know, Stoicism is a philosophy of personal ethics informed by its system of logic and its views on the natural world. According to its teachings, as social beings, the path to happiness or blessedness is found in accepting the moment as it presents itself, by not allowing oneself to be controlled by the desire for pleasure or fear of pain, by using one's mind to understand the world and to do one's part in nature's plan, and by working together and treating others fairly and justly. When he was giving evidence, the claimant said that his belief meant that the realization that the consequence of what I say would cause offence would not stop me from saying it. Section 10.2 of the Equality Act 2010 defines a belief as any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. The Employment Tribunal reminded itself of the EAT's guidance in Granger plc and Nicholson 2010, in which it was held that a belief can only qualify for protection if 1. It is genuinely held, 2. It is not simply an opinion or viewpoint based on the present state of information available, 3. It concerns a weighty and substantial aspect of human life and behaviour, 4. It attains a certain level of cogency, seriousness, cohesion, and importance. And 5thly, it is worthy of respect in a democratic society, is not incompatible with human dignity, and is not in conflict with the fundamental rights of others. The tribunal also refers to the case of Gray and Mulberry Company, 29, in which it had been commented that the bar for protection of a belief should not be set too high, but on the other hand, it was important to assess the cogency and coherence of a claimant's beliefs. Employment Judge Cheetham Kesey observed that the focus should be on the manifestation of the belief, and that it was hard to define how the claimant's particular philosophical beliefs manifested in his daily life. However, he did accept the claimant's evidence that his belief system underpins almost every act that he performed in his life. He also accepted that the claimant's position that the realization that the consequences of what he would say would not cause offence, would not stop him from saying it, was what the claimant genuinely adhered to. Applying the principles as set out in Granger, it was found as follows. In relation to whether or not the belief was genuinely held, the judge commented that there can be no dispute that Stoicism as a philosophical belief system has been around for around 2,300 years, and he considered that the claimant did genuinely believe in it. As to whether this was simply a viewpoint based on the present state of information available, the judge was satisfied that it was not. He accepted the claimant's evidence that he had a strong interest in and adherence to this philosophical belief system for a number of years, and that it transcends merely holding an opinion. On the question as to whether or not it concerned a weighty and substantial aspect of human life and behaviour, the judge considered that it plainly does. Stoicism is just one of innumerable schools of thought attempting to answer the most profound questions that we ask, and the claimant had further demonstrated this through his contextualization of Stoicism alongside the major religions. As to whether or not the belief attained a certain level of cogency, seriousness, cohesion, and importance, the judge considered this to be the overarching criterion, and as such, considered that one must be sufficiently convinced by the manifestation of the belief, as that will demonstrate these factors. Based upon the tribunal's findings, it was concluded that the claimant did apply his beliefs consistently, and it was an important part of his life. It was relevant that he was striving to achieve a state of equanimity, because that suggested a guiding purpose which gives cohesion. On the next criterion, the judge did admit to struggling with whether or not the belief was worthy of respect in a democratic society, given that it involved consciously disregarding the consequences of saying or doing something that might or probably would cause offence. However, he observed that there is no fundamental right not to be offended. He did not consider that the claimant's belief in Stoicism fell into the same category as, for example, beliefs founded on racial superiority. The fact that the claimant was driven in what he says and does by consideration of whether the action is right or wrong, rather than what may be the consequence, does not make the claimant's beliefs unworthy of respect in a democratic society. So, an interesting case. First veganism, now Stoicism. Clearly, it would appear that the scope of protection under Section 10 of the Equality Act is being extended beyond simply mainstream religious beliefs. Now, one can, of course, see the potential difficulties in a belief system in which the consequences of one's words or actions are not seen to be relevant to an individual in determining whether or not to do or say the thing, especially bearing in mind in this case that the claimant was employed as a communications worker. However, as the judge concluded, there is currently no right not to be offended, and as such, it could not be said that such a belief was not worthy of respect.
Thank you, Sarah. So, fourthly and finally, I'm going to deal with another EAT case, the case of Aramark UK Limited and Fernandez. Now, the facts of this case were that Mr. Fernandez, the claimant, was dismissed by Aramark, who I'm going to refer to as the respondent from now on. He claimed unfair dismissal. The respondent defended the claim on the basis that Mr. Fernandez's position was redundant, and so the decision was fair. Now, the parties were in agreement that a redundancy situation had arisen, but were in dispute as to whether Aramark, the respondent, had complied with Section 98(4) of the Employment Rights Act 1996. And just a quick reminder that that section states that the fairness of the dismissal, A, depends on whether in the circumstances, including the size and administrative resources of the employee's undertaking, the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee, and B, shall be determined in accordance with equity and the substantial merits of the case. Now, the respondent maintained a list of people they could turn to if they had a labour shortage, which was also sometimes called the bank or pool. That list included about 120 people with a variety of skill sets, but those people were not employed by the respondent, and there was no obligation on the respondent to provide work to those on the list. But the evidence before the tribunal showed that Aramark had frequent recourse to the list, and that those persons on the list had reasonable prospects of obtaining work on an ad hoc basis. Mr. Fernandez argued before the tribunal that the respondent should have put him on the list when he was being considered for redundancy, as it offered him the chance of employment, which was better than no employment at all. So the judgment of the Employment Appeal Tribunal was to accept that the respondent's failure to put Mr. Fernandez on the list was unreasonable and therefore in breach of section 98(4), and accordingly that he had been unfairly dismissed. Aramark appealed that decision. And in a refreshingly short 3-page judgment, Lord Somers, sitting alone at the EAT in Edinburgh, said that the resolution of the appeal depended upon the proper construction of section 98(4) of the Employment Rights Act 1996 that we've just looked at. He said that section 98(4) deals with the reasonableness or otherwise of the decision to dismiss. An employment tribunal must be satisfied that there is a sufficient reason for dismissing the employee. The section focuses on the availability of other reasonable alternatives to dismissal. But in Mr. Fernandez's case, placing him on the list would not have obviated his dismissal. Being placed on the list opened the prospect of work, but did not secure work, and so was not new employment in a different or subordinate role. That would be the position whether or not there was suitable ad hoc work available for persons like Mr. Fernandez on the list at the time of dismissal. And therefore, it followed in Lord Somers' opinion, if placing Mr. Fernandez on the list did not entail the provision of alternative employment, then the respondent's failure to place him on the list was not a decision that fell within the scope of the section. That is because the mischief, as he called it, which section 98(4) seeks to address, is the mischief of dismissal. It does not provide a statutory right to an alternative that might have had the potential to mitigate the adverse effects of dismissal. It followed that the EAT allowed Aramark's appeal and dismissed Mr. Fernandez's claim. Now, in terms of assessing the usefulness of this authority for employers wishing to assert in redundancy situations that they do not need to place potentially redundant employees on any such list that they might keep, I would urge a note of caution. The EAT at paragraph 2 of the judgment specifically stated that those on the Aramark list were not employed by Aramark and that there was no obligation on Aramark to provide work to those on the list. Hence, the issue of alternative employment did not arise. However, there might be companies who keep similar lists of pool, bank, casual, or other ad hoc workers where those persons on the list would be adjudged to be in employment, and thus section 98(4), the Employment Rights Act, would become engaged. And to that end, in assessing the status of those on their lists, employers should be mindful of the line of employment status authorities, which really started with the House of Lords judgment in Carmichael and National Power plc, but now runs through to the 2011 Supreme Court decision in Auticlens and Belcher, in which the written contractual documentation specifying that persons were ostensibly casual workers or self-employed was no longer conclusive as to their status, and courts could look beyond the written documentation to the reality of the situation as to whether there is mutuality of obligations between the parties, micro-employment contracts whilst working, or umbrella contracts which subsist during periods of non-working. Well, that concludes this case law update. We hope you found it useful. If you are interested in receiving further information from the Employment and Discrimination Law team, be it notifications of future webinars, case law updates, or our monthly newsletter, or to make any other inquiry about the team and the services we provide, please do contact our Practice Group Director, Russell Porter, who will be very happy to assist you. Goodbye.